It was held that the definition of a person interested given in Section 18 is an inclusive definition and must be liberally construed so as to embrace all persons who may be directly or indirectly interested either in the title to the land or in the quantum of compensation. It was further held that the lands were actually acquired for the purpose of the company, and once the land vested in the government after acquisition, it stood transferred to the company under the agreement entered into between the company and the government. Thus, it cannot be said that the company had no claim or title to the land at all. Secondly, since under the agreement the company had to pay the compensation, it was most certainly interested in seeing that a proper quantum of compensation was fixed so that the company may not have to pay a very heavy amount of money. This court categorically held that the view taken by the Orissa High Court or even by the Calcutta High Court that a company, local authority or a person for whose benefit the land is acquired is not an interested person is not correct. In the above case, this court further held that the preponderance of judicial opinion seems to favor the view that the definition of person interested must be liberally construed so as to include a body, local authority, or a company for whose benefit the land is acquired and who is bound under an agreement to pay the compensation. This view accords with the principles of equity, justice and good conscience. In that case, their lordships of the Supreme Court observed that the municipal corporation of the city of Ahmedabad, for whose benefit the land had been acquired, could not maintain an appeal in the Supreme Court against the judgment of the High Court setting aside that notification. It is evident from the brief order that the matter was disposed of at the very threshold without any elaborate reference to either principle or by diverting to any authority. The appeal was held to be not maintainable on the short ground that their lordships failed to see what interest the municipality had which would sustain an appeal by it against the order of the High Court allowing the writ petition filed by the landowners. The only right under the Act available to the company is to appear and adduce evidence for the determination of the amount of compensation, and the company by itself would have no right to file an appeal. It was also held that when a company has no right to file an appeal, then a fortiori, it follows that an application under Order 1 Rule 10 of the Civil Procedure Code by a company to become a party in the proceedings would not be maintainable, because once an application for becoming a party is allowed and a company is made a party, then the company would have a right to file an appeal.